I am sure you are aware there are rules in criminal procedure. If you're found not guilty, you can't be retried twice for the same crime in America. It's called double jeopardy. You know it. There are no do-overs. But tonight I want to talk about how Bryan Kohberger could theoretically be convicted of murder even if he's initially acquitted. You heard me, how the state could try him twice, thrice, maybe even 4 times. It's a long shot for prosecutors, I know, but it is not impossible. And for anybody who worried that Kohberger keeps winning all these small victories in the pretrial hearings, I want you to hold that thought for a hot minute. Case in point, just this week, a judge ordered the prosecutors to turn over some DNA evidence to investigators, to the defense attorneys. It's the evidence that the investigators used to link Kohberger to the crimes. The defense wanted it, prosecutors didn't want to give it, judge said you got it. It doesn't sound like a whole lot, but it does give the defense an opportunity to pick apart every single piece of the prosecution's case, and that could make a difference when it comes time for trial. I mean, apart from the DNA allegedly found on the knife sheath at the murder scene, which is huge, there's not a whole lot of evidence providing a solid link between Kohberger and the murders. And so if he can get that DNA tossed, convicting him could get a whole lot harder. And that is why prosecutors may need to get creative. Here's how. Try Kohberger separately for each of the 4 victims he allegedly killed. 4 separate trials, one after the other. 4 chances to get a conviction, 4 separate bites at that very same apple. And before you say that can't happen, it's happened before in a case with striking similarities. Follow me. On June 6, 1996, police in Rowlett, Texas responded to a report of a stabbing at a family home, nice home in a nice community, wealthy family. When the cops got there, they found 2 little boys fatally stabbed in the chest, and their mom had a stab wound to her neck, but she was still alive. The dad, seated there at the gravesite, he was with an infant sibling upstairs, and they were fine, those 2. The mom's name is Darlie Routier, and she told the police that when all of this happened, she was sleeping on the couch with her 5- and 6-year-old boys when suddenly she woke up to an intruder who was stabbing her, and he'd already killed her kids. Horror. But the police, they said they had spidey senses. They just didn't buy the story. And then they started to find a whole lot of inconsistencies in her story. And they said the physical evidence at the house, at the crime scene, actually pointed to the killer maybe being inside the home. So Darlie Routier was arrested and charged with both of the murders of those 2 little boys. And prosecutors got creative. They decided to try her for only one of the murders, her 5-year-old son, Damon. If she happened to be acquitted, they figured they could try her again for the second one, the 6-year-old, named Devon. That's what you call 2 bites at the same apple. It turns out Darlie Routier was convicted, and she was sentenced to death in that first trial. And she's been on death row for the last 27 years. To this day, she has never been tried for the second little boy. She's never been tried for Devon's murder. No one has been. So what does all this mean for Kohberger? For that, I'm joined by Jesse Weber. He is an attorney and a legal contributor for NewsNation and an anchor on the Law and Crime Network. Also, very, very smart. And I call him a lot for help, like tonight. So, Jesse, where am I wrong in this strategy when it comes to Kohberger and 4 murders?
Ashleigh, you're never wrong. You're never wrong. But look, here's where I'll say the complication is. In the Routier case, that theory was never tested because she was convicted. The problem is when we talk about double jeopardy, even when you have multiple victims, the Supreme Court has said that is part of the same offense, and that can be double jeopardy. There's a case from the Supreme Court called Ash v. Swenson. I encourage everybody to check it out. It was about a robbery of multiple victims, and you had one of the defendants who was actually acquitted with respect to one of the victims, but couldn't be retried with respect to the others because it was all part of the same offense. Now, theoretically, is it possible prosecutors would say, hey, listen, let's just try him for 2 of the victims in the Idaho case, see what happens. They could make an argument that, it's two separate kinds of, we tried them for these two killings. We don't know what's going to happen with the other two. I don't think it's going to be successful. I don't think they want to risk it. And even putting aside the issue of double jeopardy, this is a really tough case. I don't think a judge is going to want to have 4 separate trials that could potentially traumatize the family on top of the cost, the litigation of having 4 separate cases.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.